Hi, my name is Alejandro Perez Perez, and this is the AI Coffee Podcast. Every week, we will have one disruptive aspect of technology and artificial intelligence for the time you drink a cup of coffee. Today, we are going to take AI from another perspective and discuss about intellectual property about AI. For doing that, we have a very, very intelligent and clever person. Welcome, Robert. How are you?
I'm doing very well. Thanks for having me, Alejandro.
Robert Plotkin is a patent expert specializing in software patents and AI innovation. He is the founder of Blue Shift IP, author of multiple publications, including two books, The Genie in the Machine and AI Armor, which explore the intersection with AI and patent law. Wow, Robert, you have such a different background because usually people coming to this podcast are more, let's say, talking about technical aspects of AI or data. And in your case, you are specializing on patents and regulation, which I think is very, very different and interesting for us, for the audience. So the first question I would have is why did you decide to go on this field, on this direction from your personal and professional perspective?
I've always been a engineer, inventor, software developer at heart. Started programming computers when I was a kid back in the early 1980s. Studied computer science at MIT. And I also had another part of me which loved writing, arguing, strategizing, all of those things, and in particular in relation to technology. So that motivated me to go to law school. And then practicing patent law was a perfect combination of all of those interests and skills of mine. So for almost 30 years now, I have been helping individual inventors, startup companies, and established companies obtain patent protection for their innovative software. And in recent years, increasing amount of innovations that use AI.
That sounds really interesting, but not very usual to study law after studying from the MIT. I don't know if you have many of your colleagues of the engineering school, let's say, then go into law. Is it common from your perspective, or I mean, how do you say it?
It's not that common. It's not that common. I'd say most people who go from engineering to law do go into patent or intellectual property law because it enables them to make use of their science or engineering background.
hmm But it sounds a good combination, though. I think it's really really great. And Robert, you also, as I mentioned before, have two books and also a podcast. Maybe we can discuss about it later. But you work a lot on your personal brand, and I think it's also a very important part of yourself about what you are doing and also why you are here. So how was the process of investing time and effort on your personal brand, and why did you decide it?
Yeah, I mean, first of all, I just love writing about the work that I do, educating people about it, helping people understand how they can benefit from patents and intellectual property. It's just part of who I am. Uh, I enjoy dispelling myths about intellectual property, and there's many of them. You know, there's many people in the software world, for example, who think that you can't obtain a patent on software, and that's not true. We do it all the time. There's also a lot of people who think that even if you can obtain a patent on software, those patents aren't valuable or worthwhile, and that's also not true. My clients use software patents to help them raise money for investment, help them increase the value of their companies for getting acquired or going public. They use patents to defend themselves, often against much, much bigger companies. But there's a lot of misconceptions about all of that. And I enjoy educating people about that. And then that simultaneously helps promote my own personal brand and the brand of my firm, Blue Shift IP. So it's all a benefit.
hmm Actually, when you were talking about patents, or even when I was preparing this episode, I was thinking that maybe the most relevant misconception about patents is that they are boring. I don't know if for many of the people in the audience is going to be the same, but whenever I think about patents, about intellectual property and things alike, I think they are very boring stuff that maybe they are necessary somehow while doing business. But do you think they are really, I mean, an exciting thing for you or for a company starting a product, for example?
I mean, the patents that I obtain for my clients are on their most cutting edge technologies. So that's part of what I find most exciting and motivating about the work that I do. I'm constantly getting to learn about the newest technologies, often years before they hit the market. I mean, when I file a patent application for a client, it's
Mhm.
often when they're just starting to develop some new algorithm, or in the case of AI, it might be a new way of training a machine learning model, or of applying machine learning for personalized medicine or for robotic control. So to me, that's not boring. That's really, really exciting. Now, it may be the case that the process of writing a patent application can be very tedious. And that's when you say people find it boring. If they've had to work on a patent as an inventor, and they've had to review a 50-page document, that can be tedious and boring. But the content of what's being described and protected is extremely exciting to me.
Okay, that sounds really nice, and hearing that. And Robert, what can be patent actually?
So I'll say generally what can be patented, but I'll focus mostly on software again because it's my focus and it's where there are the most misconceptions. You can obtain a patent on essentially a machine or a process. And a machine is easiest to understand. Imagine a new kind of car engine. That's a machine. Uh, it if it, let's say, burns fuel more efficiently, and it has some mechanism that enables it to do that, you can get a patent on that mechanism. All kinds of machines. And what does that patent give you when you get that patent? It enables you to block competitors from selling or manufacturing that patented invention. So it's very powerful. And you can then either use the patent to make and sell that technology on your own so you don't have competitors and thereby charge higher prices or get more customers. Or very commonly, you might license the patent, meaning charge a fee to your competitors to manufacture that car engine. And there's lots of companies who primarily or even exclusively invent things, license them to other companies to manufacture. And in that case, the patent owner is not doing the manufacturing or selling directly, they're just licensing to other companies. And there's famous companies out there like Qualcomm that of course sells a lot but also does a ton of patent licensing like that because it's a very innovative company. So that's the first type, is a machine, easy to understand. But you can patent processes. Those are a little bit harder to understand. You can imagine an industrial process, like a process for manufacturing a component, like a chip. And if you have a manufacturing process that's more efficient, you can patent the process. It's the process isn't a physical thing, and that's why it's harder for people to get their heads around what a patent on a process is. But the process is a sequence of steps that's new and useful. And if you have a patent on it, it means just like a patent on a machine, you can block other people from making use of that process, let's say, to manufacture a chip. And so software is essentially a kind of embodied process. And if you create a new kind of algorithm, let's say for compressing data or encrypting data, or these days for training a machine learning model, you can get a patent on that process. And then that gives you the ability to block others from using that process, or to license the process to other people, charge a fee for it. Is that helpful?
Yeah, it sounds helpful, I think, but I still have doubts, for example, when we talk about software, because, for example, as a developer, sometimes, I create code. Is it possible to patent, like, let's say, a notebook of code like that, or a piece of code? Like, for example, I was thinking that I was really innovative and I created a way, for example, of executing a machine learning model really efficiently, for example. Is it possible to patent that?
So you typically would not patent the code. Uh, what we try to do when writing a patent is to describe the process at as high a level as possible. So if you have a method for training a model and it has a few steps in it that are new and different and that enable that training method, let's say, to be more efficient than before, in the patent, we describe that method in a way that's independent of the code as much as possible. Let's say that describes the method in a way that can be implemented in any kind of programming language on any kind of platform, so that when you get the patent isn't limited to just a specific language, a specific platform, a specific type of code. Uh, that would be the power of a patent on a software method. You can get copyright protection on the specific code. And there can be benefits to that. Specifically, if you have, let's say, you hire someone to write code for you, and then they take that code and bring it to their next company and just copy it. Copyright is the easiest, least expensive, usually way to block that kind of copying or knocking off of
Hmm.
what you've done, because they've just literally copied the code that you own. Patents cover the higher level process, and that's one reason why they're broader and can be more powerful than copyright. Another reason patents can be more powerful than copyright is that a copyright is only infringed when someone has your code, let's say this person you hired, and they copy it. But if someone else sees your product, let's say, and they see the feature it has and they like that feature, and then they go ahead and write their own code that does the same thing, they're not infringing your copyright because they wrote their own code. But with a patent, if they copy the feature that you've patented, they can infringe your patent, even if they wrote different code than you wrote, as long as they both perform the same process. In fact, someone can infringe your patent without even knowing that you or your code exists. If they come up with the same idea after your patent and they create a piece of software that does your patented process, then they're infringing your patent even if they didn't know about you. So those are some of the ways in which patents can be quite powerful.
Hmm. Yeah, now I see the importance of having a patent because, as you mentioned, now in the startup world and also with AI, with so many new things coming every day, it's very important protecting your own innovation, I think. But um, is it how is the process? Because I mean, just can you explain it for dummies? Let's say, like, how is the process of creating a patent, and also, as you mentioned, I think it's very, let's say, funny or important that maybe if another person does the same thing you innovated to, you can have like send this person a letter, or how it works to tell this
Yeah.
person, hey, I have this patent. How does it work?
Yeah. So, at a high level, the way the process works is if you've come up with something, again, a new process in the context of AI, very often it's a new method of training or some new use of a machine learning model, maybe for detecting malicious software code or malicious activity on a network, or maybe for recognizing images, any of those things. If you think it's a new, innovative method that would be valuable in other companies' products, you contact a patent attorney like me. And then the process of working with me involves educating me about what your invention is, what you think is patentable. I give advice to my clients, first of all, on just is this the type of method or process that can be patented at all? Because sometimes they can't be. And then I'll do research. Is it really new and different enough from previous software to be patentable. And then if it is, we write a patent application. And the patent application describes the invention in a very specific type of way uh, based on the patent law. And I work with my client, and if it's a company, it's something that's multiple inventors. They review what I've written to make sure it describes their invention accurately. And I try, as I said, to abstract from their invention to give them broad protection against other companies that might implement the same invention but in different ways. We try to stretch that as much as we can. Then we submit that patent application, it's a document, to the patent office. And it gets assigned to someone at the patent office called an examiner who reviews the patent application and decides whether they think it's entitled to a patent. Usually they reject it, and then I have to review the rejection, talk to the inventors or the client. We speak to the examiner, we respond, and then there's some negotiation, usually back and forth, uh, to eventually get the patent. This can go on for a few years, actually. There are ways to speed it up. At the US Patent Office, you can pay an additional fee, and I've gotten patents sometimes in under a year when we've sped things up. And of course, in the case of software and AI, where things move so rapidly, getting a patent quickly can be very, very valuable compared to waiting 3 or 4 years. Uh, Once the examiner approves, the patent is granted, and that's when you can enforce it. So that if you see a competitor putting the same patented feature in their product, you can enforce your patent against them. And as you said, you can contact them directly, attempt to resolve things in a friendly way. Usually they'll either stop or you enter into a negotiation for what I mentioned, a license, which means they'll pay you for the right to use it. If not, you might have to sue and engage in a lawsuit, which you try to do as a last resort because patent litigation in the US in particular is very expensive. It's very time consuming. In fact, in recent years, there has become available financing for patent litigation. You can get funding externally for patent litigation because it's so expensive by an investor who will pay if they think you have a strong case. And then, of course, if you win, the investor will take some part of the
Wow.
proceeds. It gets split up between the patent owner, the funder, and the patent litigation firm. And I've had clients who have done that in order to enforce their patents because they can't afford to do it on their own.
Mhm.
That's the short story of the basics of patents, how you get them and how you enforce them.
It really sounds that you're really passionate about that when you are talking about this, and yeah, it sounds like you really like it. But how is it, for example, if I live in the European Union, I live in Spain, and I have a patent here, and then another company wants to have another patent in the US, for example? How does it work?
Yeah. For better or worse, patents are national. Uh, so you have to get a patent in the US if you want to enforce it in the US. In Spain, you can apply to the European Patent Office. It's a little confusing. It's not the same as the European Union, it's a different organization. A lot of overlap, but not exactly the same. For example, UK is still a member of the European Patent Office. Brexit didn't affect that. Uh, but for the most part, with the European Patent Office being a key exception, you apply in each country where you want patent protection. And as you can imagine, that can start getting very, very expensive. And so even big companies make very careful strategic choices about where to apply for patents. And sometimes, for example, you can get a lot of benefit just by filing, let's say, in the European Patent Office and the US Patent Office. Because imagine, let's say it's for some AI software. If you could block your competitors from selling to customers in Europe and the US, that's going to put a significant barrier against them, even if they can sell in China and Japan and elsewhere.
Hmm.
And particularly if a large company, let's say a Microsoft or a Google, wants your technology, if you're able to stop them from entering the European or the US market with a patent in those jurisdictions only, that can give you a lot of leverage to sell or license the patent to them, even if they're free to sell in the other countries where you haven't obtained a patent.
Hmm. Yes, actually, I was looking at that before, and I think the European Patent Office is even in Spain. Even though I know that what you mentioned, it's very complicated because now with the Brexit, UK is still, but not. I mean, it's a little bit complicated somehow.
Right.
But I guess that, I mean, someone with imagination and creativity would, for example, look for which countries have patents for different products. For example, I don't know, let's say Google or Meta or something like that. And maybe in some countries, I don't know, the whole world, there are like a lot of countries. So maybe in different countries, you could create a copy of Google patent over there. Is that possible?
If someone wanted to use Google's technology in another country, you're saying?
Yes, imagine that, I don't know, I could find a place in the world where Google is not patent, for example.
Right.
So is that possible that in that country, that specific country, I could myself create a copy of Google, calling it differently, and use it as it was the same technology, but with my own patent? Is that possible?
Right. You probably wouldn't be able to get a patent on it, but you might be able to sell and use a product or a service in that country that wouldn't infringe a patent by Google because they don't have a patent in that country. You'd have to
Hmm.
be careful about trademark, like you couldn't use the name Google because that would infringe their trademark. Uh, but this is, yes, there are companies that do this. It's more common with physical goods, clothing, electronics, other things like that, that companies will find places where those are not patented and then manufacture and sell them in those countries. But it can be done with software as well, certainly.
Hmm. It sounds really weird, let's say, for me. But well, maybe an opportunity for someone. Yeah, let's say so. But let's come back to AI because you mentioned a little bit before, you talk about AI, the AI war with patents nowadays. And you mentioned something that I think is very relevant, that patents time usually takes a lot of time for patent a product or a software, and with AI these times are not valid anymore. So how do you see maybe the future with AI regulation and patents? Would it be maybe possible to accelerate it somehow, much in a better way, rather than just paying an extra fee, as you mentioned? Is that possible? I don't know if in the US, in the
Yeah.
Europe. How do you see it?
There's different countries have different mechanisms for speeding up the patent process. Some of them, like the US, you can pay a fee. It's also possible that if you get a patent granted in one country, like the US, you can then use that to speed up the process in many other countries. Uh, Also, for example, in the US Patent Office wants to encourage the development of certain types of technologies, like energy efficient technologies, cancer fighting drugs and technology. So the Patent Office has a set of categories of technology. And if your invention falls into one of those categories, they will speed up your invention. And so every patent office has its own policies like that to speed things up. But the two key ones are, in fact, in the European Patent Office, you can just request acceleration. There's not even a fee. So it's very common for companies to file there, try to get something granted quickly, and then go to the US and use the patent from the European Patent Office to speed up processing in the US. But one thing I should mention is that even when the process of getting the patent granted is slow, just filing a patent application does give you some benefits, even while you're waiting to get the patent granted. So I have a lot of startup clients who file patent applications early on. And then when they're going to get additional rounds of investment, they'll let the investors know that they have filed patent applications, and that's helpful. When they're talking to companies to get acquired, the fact that they have patent applications filed, or it's called pending, is very, very helpful. You can't enforce your patent rights yet until the patent's granted, but still, investors and acquirers and other people who are familiar with the system know that there is value in having patent applications that are filed.
Hmm. But let's continue talking about the future because you mentioned different process for speeding it up. But how do you see the future? Because patent is something, let's say, that comes from all times. And I think even remember that I think Einstein was a patent agent, if I remember correctly. And it was 100 years ago, a little bit more, I think. But I mean, it really comes from an old perspective of protecting inventions and innovation, which I think is very relevant. But do you see that this could be valid in a world with innovation is every day, and the rhythm of all technologies are very different from, for example, 100 years ago?
It's very different, but the need is still there. I mean, let's take a look at AI and startup companies, for example. Just look at how many startup companies have put time and effort into developing really significant innovations. And then you wake up the next day and see that OpenAI or Microsoft or Google has incorporated those innovations into their platform. I mean, this is happening so rapidly. So it creates a lot of uncertainty amongst innovators when they have to ask themselves, should I really be putting my time and energy and money into developing something innovative if one of these big companies can just come along and take it? And then once a big company puts something into their own platform, how can a small company compete against that if something is now in Microsoft Windows or built into ChatGPT or the iOS? I mean, a patent is one of the few things that a small company can use as leverage against a big company like that. So I actually would argue that patents are more relevant than ever in this time of really rapid innovation to provide small innovators who are extremely valuable to all of us and critical, to give them the motivation, the incentive to keep innovating so that they know that they're not just at risk of being having their technologies assimilated by a large company without having any way of getting compensated for it.
Hmm. Yeah, I get the point, and I saw many often, as you said, many times, many startups, many small products, like with running with AI. That then, at the end of the day, 1 month later, OpenAI takes the same kind of tool and they integrate it into the system. And now this startup, of course, finished because there is nothing else to be done, of course. So, so in your opinion, like intellectual property is more relevant than ever. I get the point. So should we maybe invest more from the public sector to have, let's say, better process of producing these patents and working with that? Because as far as I understood from your US perspective, you mentioned that in the US maybe the process is very slow, and maybe in the European Union it's a little bit like like faster, but still, I mean, it's a long process that maybe for these small companies that are like, this is that maybe the main idea of protecting them and their inventions, maybe they cannot afford like a 2 years process with a lot of bureaucratic stuff. How do you feel it?
Yeah, this has always been an issue, certainly with software in the almost 30 years that I've been working in the field. Part of the problem at the US Patent Office is they can just never hire enough patent examiners. They're always backed up because the number of software patent applications that are filed just exceeds what can be handled quickly by the number of people they have. So the Patent Office is always working on hiring more people. They're doing their best, I think. But it's interesting. In recent years, the US Patent Office has made more use of AI to assist in the patent examination process. to streamline and automate some parts of it. Things like searching for prior patents. That's been significantly assisted by the use of AI and natural language searching. A lot of routine types of tasks. The patent office has been, U.S. patent office has been investing in using not just AI, but just other kinds of software to enable patent examiners to be more efficient in their jobs. And I think that there'll be lots more opportunities for that kind of work to be done to streamline the process.
Mhm. Very interesting that point that AI is going to help the patent office to help AI also. Yeah, it's funny that circle.
I mean, let me just
Uh,
mention that, of course, what is patent examination? To a large extent, it is a process of understanding and comparing documents with each other. I mean, that's something that today's large language models are getting really good at doing. It's not all that's required, but intelligent use of language models and text-based AI and image-based AI for doing patent examination would be really, really helpful just because of the nature of the process involves understanding different technologies as described in documents and comparing and contrasting them with each other.
mhm. Yeah, that's true. That could really speed it up because at least let's say that the officer doesn't really need to go into thousands of books or papers just to read them. It could be much more simple to create this research as you mentioned. But Robert, I want also to talk about another topic which is relevant from your let's say from your personal background, which is writing books about AI because you wrote already two. Um, one of these, one of the of those has the name AI is the AI armor. Like you are really establishing that we need to be protected from AI somehow, right? So can you explain why you chose this name and also how is the process of writing two books actually about AI about law nowadays?
Yeah. So the book AI Armor, what that means is using intellectual property to protect your company's AI innovations. And so that's based on my experience over many years obtaining patents for innovative types of AI. It explains my process for working with clients to obtain patents for AI. The first book was called The Genie and the Machine. It was published in 2009. I actually started writing it several years earlier, maybe 2004, 2005, because I started to see AI at that time being used to automate the inventive process. People were using AI then to help design drugs. They were using AI to design circuits. They were using AI to write code in much simpler ways than we're seeing today, but it was starting to happen. And people were even starting to get patents on inventions that were either, you would say, invented by AI or that where AI significantly assisted in the process of creating the invention. So that caused me to wonder, well, what's the impact of this on the patent system? If software can generate something that's patentable, a design for a circuit, a design for a drug, write code, what's the impact on the patent system? I mean, the first one big question that arises: do we need patents anymore at all? If inventions can be created automatically, do we need to change the rules somehow to account for this? Should it become more difficult to obtain a patent if AI is making it easier to invent things? I mean, it raised all of these questions. So at the time, this was before deep learning. It was way before large language models or anything like that. In fact, it was evolutionary algorithms that were the primary type of technology I wrote about. I interviewed many people in the field, including people who had obtained patents on inventions created using AI. And so I knew the book was a little early, but I think I didn't realize it would take so many years for people to become more interested in it. I think at the time, not too many people cared because they thought this is somewhat science fiction. It's not really real. Uh, and then, once ChatGPT launched, everyone started talking about what is the impact of this on intellectual property, including patents? And can AI be an inventor on a patent? What's the impact of AI on the patent system? And I thought, well, I've thought a lot about this. I've worked on a lot about this. And so that motivated me to write the next book, which is much less theoretical. The AI Armor is much more of a practical guide. Anyone who is starting a company, who is a CEO, CTO, advising an AI company, can read the AI Armor book and understand it because it describes strategies for applying patents to AI innovations.
They are both on Amazon, just for mentioning that, because maybe someone in the audience would be interested on those. But I get that the process of writing a book is very tough, and as you mentioned, you did a lot of research, and it's funny because your first book maybe was too early, maybe I don't know, but. I was thinking only a couple of times, maybe a couple of years ago, that now a lot of papers, scientific papers, are written by ChatGPT, for example, or let's say maybe not written, but at least maybe a part of the abstract and maybe something like that. But I have never thought that maybe like inventions, like the whole inventions, could be done by an artificial intelligence. But it has a lot of sense, and it's very interesting to get the point because who's this invention? The person who invented the AI system, the person who uses it. Sometimes it's very tricky, so yeah, very very relevant. And can you explain a little bit? Maybe I don't want to do a spoiler of your book, of course, but I'm very interested on the second book of the armor because you mentioned that it's very practical. Can you maybe say one, two main advices that you could give maybe to a startup starting, or I don't know, the board of a company to
Right.
think about patents?
Yeah, I say two high level things to know is that if you develop any new type of AI, let's say it's a method of training a model, it's really important to think about, can that be patented? What would the value of a patent be? Or should you keep it as a trade secret? Uh, and there a variety of factors have to be taken into account. A trade secret, think of it like the formula for Coca-Cola is a trade secret. You don't apply to the government for a trade secret. It's information or a process or knowledge or know-how that a company has that gives it a competitive advantage that other people don't know about. And there's some real benefits to trade secrets. One is they can last forever, they don't expire. And two, because they're secret, you don't give anyone else the ability to copy them easily or compete with you. And so when it comes to a method, like a method of training a machine learning model, if you have a new method like that, and let's say it's innovative enough to be patentable, that doesn't necessarily mean it's the best business decision to patent it. It might be better for you to keep it as a trade secret because when you patent it, you have to file a patent application where you describe how it works, and then all your competitors can see that, and they can use it to copy, maybe in secret in a way that would be hard for you to detect. So maybe they could infringe your patent and you wouldn't know that it's happening. The book describes a variety of ways to evaluate patent versus trade secret protection. This is a really fundamental strategic and tactical decision. That's one thing that the book will explains. The second is that AI related innovations often have many different components to them. And again, I'll use, let's say, a method, a process that involves training a model and then applying the trained model. You could think of those as two different processes that also can be combined together into a bigger overall process. And when you're thinking about patenting, it's really important to break down what you've created into its different components and analyze them separately so you can decide, should I patent one? Should I patent the other? Should I keep one as a trade secret and patent the other? Should I patent them together in combination? Should I patent them separately? It's very, and I see a lot of companies not doing that, and they don't think through the pros and cons of the different alternatives, and as a result, they can end up with patent protection that's not really beneficial to them. Those are the two key takeaways I think from the book.
That's fine. I would add a third one is or buying the book or contacting Blue Shift, which is your company, actually, for more information, which I think you could help any startup or any like company starting a new product who with like really a lot of insights as you prove here. But we are almost ending the episode, so I have just a couple of questions to finish. So the first one is what's next for you? What's because as you mentioned, you came from MIT, you then study law, you also work on your personal brand, you have two books, you work more in the patents, let's say atmosphere landscape, and then now since almost 8 years you have been working on your own company. So what's next for you?
Well, right now at Blue Shift, which is the patent law firm that I co-founded, we are extremely busy helping clients obtain patent protection for their AI innovations. So, that's what I'm doing a lot of now. I love working with companies that are innovating in software generally. It could be any field of software, but in AI in particular. So that's what I'll be continuing to focus on for the foreseeable future. I do love doing things like this, talking on podcasts, webinars, conferences about all of this. Continue to post on LinkedIn really frequently. I love hearing from people about what they'd like to know more about. I love, in a sense, giving this knowledge away for free. And the book is very inexpensive, but I know that in the end, if someone really wants a valuable patent, I would hope they would contact me and know that it's not something that they should be doing on their own. In fact, I think of the book as a tool to help companies become more effective as clients for a lawyer like me, so that they can work with someone like me in a way that's more effective and efficient for them to get better results, because now they are armed with knowledge that can help them evaluate options and make better decisions when they work with someone like me to obtain patents.
Hmm. That's a very interesting point of view and an idea for the next years of your career, let's say. So I wish you all my luck. And just two questions for the end, Robert. This is the AI Coffee podcast. So at the end of every episode, I usually ask all my guests, which is your favorite type of coffee? Because coffee is very relevant here. And then the other one is how can the audience contact you? If, for example, they want to know more about patents, I don't know, have more information, yeah, let us know.
Favorite type of coffee? I'm pretty simple. I just like a dark French roast. That's what I like.
Great.
Nothing complicated. None of the sweet, syrupy, sugary concoctions.
Nothing but
Uh,
coffee, let's say.
just coffee, a little bit of cream in it. Maybe that's it. And how can you contact me? You can go to blueshiftip.com. That's our website. Or you can go on LinkedIn. Uh, Look me up, linkedin.com/in/Robert Plotkin. That's my
Mhm.
profile. I usually post 2 or 3 times a week. I've been posting recently about the pros and cons of broad versus narrow patents. That's the theme that I'm on now. But I'm always posting on different themes, always relating to patent strategy, software patents, and sometimes about AI in ways that are not related to patents at all, but just about AI, how to use it, impact it's having on humanity, which is another topic I'm really passionate about.
Wow, really great. Any other thing you want to add at the end, Robert?
Just thank you. Thank you so much for having me here. I really enjoyed talking with you and having the opportunity to speak.
Thank you also for your interest into coming to this podcast. I think we all have learned a lot about patents today. So I think a very relevant tool that maybe we have a lot of misconceptions about them. But thank you very much. Thank you.
Thank you.
And also, thank you to you that are watching until the end. If you liked it, please subscribe to the podcast, like and share with your friends, and of course, patent with him if you really need it. Let's stay in contact and see you next time. Bye bye.